members. I trust you can hear me clearly. Can I just get an indication on whether I'm audible?
Yes, Chair.
Thank you. Thank you, Honourable Bartman. Honourable members, thank you very much and welcome to this afternoon's meeting. My apologies, our previous meeting this morning ran way over time. We were also dealing with a negotiating mandate for the Ncop. I wish to welcome all members to the meeting. I see currently Honourable Bartman, Honourable Herron. Perhaps you can just quickly, all members that are in this meeting, if you would just quickly introduce yourselves, I'll appreciate that.
Deirdre Bartman, member of the committee.
And Brett Herron, member of the committee.
Thank you very much, honourable members. And then also from the Department of Environmental Affairs and Development Planning, I believe Mr. Mohammed and some of his colleagues are with us. Mr. Mohammed, if you don't mind introducing yourself and then your colleagues.
Good afternoon, Chair. Good afternoon, members. I'm Ayub Mohammed from the Department of Environmental Affairs and Development Planning. From our side, we've got Mr. Paul Hardcastle and Ms. Anique Rousseau. And then from the Department of the Premier is Michelle Mellon. I think that is the departmental reps. Yes, thank you, sir.
My apologies, members. It seems to me I've been speaking to myself for the last few minutes. I don't know where I muted myself, but a hearty word of welcome. It seems to me as if our legal advisors may also not be here. And I was thanking Ms. Ncop for assisting us in keeping the process on track and for assisting us in finalizing our negotiating mandate for our members in the National Council of Provinces. I trust that by now you know all the rules of engagement for video conferencing and that I don't need to repeat all of that. If needed, I will just be reminding people of that. Unfortunately, you also know that there's no interpretation service available during our committee meetings. Then, honourable members, we have been meeting on both the National Forests Amendment Bill as well as the Nema bill. And at our last meeting, we dealt with clauses 33 to 82. Having received the response from the National Department of Environment, Forestry and Fisheries, unfortunately at that meeting, our Western Cape Department of Environmental Affairs have not been able to study the response from National and to comment on that. And we then asked them to please provide us with their comments. It was expected that those comments would be reaching us yesterday morning, but unfortunately, and I think we can all agree with that, this bill is quite a daunting one. And my impression is that their response have only been forwarded to our members few hours ago. Perhaps, Ms. Ncop, you can just confirm whether I'm correct?
That is correct, Chairperson.
Good. So, honourable members, just in terms of our timeline going forward, we need to forward our negotiating mandate by the end of September. We know that we have a constituency week after this coming Friday, and therefore we have only got this week to finalize this negotiating mandate. We are scheduled to meet until 4 o'clock this afternoon. Ms. Ncop was so kind to also tentatively put on the program 2 additional slots for us to consider these bills. And obviously, I believe I speak on behalf of all the members if we say we would very much like to finish this process as soon as possible, while still paying it the necessary attention. Thank you, Advocate Marstorp. I see you've also just joined us. You are most welcome. So, honourable members,
Thank you, Chair.
In terms of resolutions that we agreed to, as I've now said, we did ask the Department of Environmental Affairs and Development Planning to provide us with appropriate wording for possible amendments to the proposals where we didn't feel comfortable just to support the clauses in the bill. And those were then listed, and I'm not going to repeat all the clauses where we thought that amendments would be necessary. And we will now be going through and that's my proposal. First, the National Forest Amendment Bill. That is the shorter one. It's more brief, and I think there are less questions, and obviously it only speaks to one act, and that is the National Forest Act, and that we start off with the simpler of the 2 tasks that we have on hand, and then commence with the consideration of the NEMLA bill, if that is fine with members. Good. So, honourable members, that is my proposal, that we now first have in front of us the National Forests Amendment Bill, as well as the I think Ms. Ncop is already able to, on our previous deliberations, screened or put on our screens the proposed negotiating mandate flowing from earlier discussions and what we've already agreed to. Ms. Ncop, would you be able to put that onto the screen now?
I'll do that, Chair.
Thank you, Ms. Ncop. And apologies, members, I just jumped up to close the door to see if I can eliminate some of the background noise here on my side. Ms. Ncop, this document, or perhaps I must ask the members, I don't expect that members would have been able to peruse this already. So my proposal is that we go through this paragraph by paragraph. Is that in order?
Chair.
Fine.
Thank you, Chairperson. I just want to ask a clarity question. I would like to know when we go do the clause by clause, because we've also previously in committee agreed to the suggested amendments by the department to certain clauses, and then there were some that were left. So I just want to know, are we going to deal with those that are left, or are we going to go through everything again? Just some clarity, Chairperson. Thank you.
Thank you, Honourable Bartman. My proposal is that we now only deal with the negotiating mandate, as we have in the past gone clause by clause and then highlighted a number of clauses where we felt that comment was necessary, or that we felt that perhaps an amendment was necessary, or that a word should be inserted, as, for example, with this first clause that we are about to consider. So we're not going to go in the bill clause by clause, but we're going to skip those clauses that we have already dealt with and on which we felt that no comment was necessary. And Ms. Niekerk was so kind to list for us the clauses that do require a submission to the Ncop. Is that in order?
Yes, thank you, Chair.
Good. So, honourable members, the first one was clause 2, and there we want to submit to our representatives at the Ncop that the word long-term be inserted between the word the and the word benefit, so that it would read the long-term benefit. Good. Can we go on? And that is what we already agreed to. Can we go on to clause 6, Ms. Niekerk? There it is submitted that deference be made to electronic and social media by inserting the words as well as on electronic and social media after the word nationally. Agreed to. Then Ms. Niekerk takes silence as approval. Then the next one, I think, is clause 9. The proposed addition prohibits any mining activities within state forests, with the exception if an existing agreement exists or in terms of applicable legislation. It was felt that the words applicable legislation may be too broad and unclear, and therefore that the sentence will end after the words if an existing agreement exists, and that we delete all applicable legislation. Thank you. Clause 15, in terms of clause 15, which provides for appeals against decisions by officials, the feeling was, or the proposal was, that appeals should have also a timeline, and there it is submitted that consideration be given to incorporating the detail as well as the timeframes of the appeals process in the regulations and not in the amendment bill, because the timeframes and also the process to be followed could perhaps, once tested, be changed somewhat, and that is our proposal then to the Ncop in terms of the National Forests Amendment Bill. Honourable members, I now put to you then that we as a committee adopt this negotiating mandate in terms of the National Forests Amendment Bill. Honourable Bartman, I see there's a raised hand from your side.
Yes, Chair, I move to adopt.
Thank you. Is there support? Is there a different view?
Yes. Yes, Chair, there's a seconder.
Good. Thank you very much, Honourable Maseku. Honourable Maseku was also pressed for time over lunch because she was also in that previous meeting that ran way over time. So thank you, Honourable Maseku. That then deals with the National Forests Amendment Bill. So thank you very much. And as I've said initially, that is the easier one for us to deal with. Now, honourable members, we will be going back to the NEMLA bill.
Chairperson.
Ms. Niekerk.
Just in terms of the mandating procedures of Provinces Act, where we confer authority on the delegate in the Ncop, am I correct in saying that the committee then supports this bill?
We support this bill, but we do want the NCOP to note the following proposals.
Okay, Chair. Just for procedure, may I then just ask that you read the beginning of the report into record, please?
Good, thank you very much. Now, having made the decision, we say that the Standing Committee on Agriculture, Environmental Affairs and Development Planning, having considered the subject of the National Forest Amendment Bill, B11B of 2016, NCOP referred to it in accordance with Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to support the bill. The committee further proposes the following amendments, as we've just discussed. Thank you very much, Ms. Ncop, for pointing that out to me as well.
Thank you, Chair. Thank you.
Thank you. Thank you, honourable members. Obviously, we now need to close those documents, or we can close those documents on our computers and put those files aside. And I now ask then of the Department of Environmental Affairs and Development Planning if they could put on the screen that document that unfortunately we were not able to read in preparation for today's meeting, because it was really circulated only a matter of hours ago, earlier today, and which may delay us. But on the other hand, honourable members, I think I speak on behalf of the committee if I say we would very much like to finish what we can finish today. So thank you very much. I don't know who is flighting that for us now. Mr. Mohammed.
Mr. Chair, it is Anik Rousseau has got it open, and between Anik and Paul Hardcastle, they will lead the discussion on this, and I'll come in on certain matters, and obviously Michelle is welcome to participate as well. So I'll hand over to Anik and Paul. Thank you.
Thank you, members. If that is fine with you, I'm going to give over to the officials to please deal with the report that they've prepared for us. Thank you very much, Ms. Rousseau and Mr. Hardcastle. Over to you.
Thank you, Chairperson. So first of all, just to confirm that this is in response to the meeting we had on the 8th of September, where you requested us to provide you with our inputs on certain specific issues. Before we get to that, you will note we've indicated how we've shown changes to the bill and additional proposed amendments. So just to confirm, it indicates deletions with brackets in bold and underlined inserted text. What we've done is we have indicated deletions by a strike through, and additional insertions we have included as bold underlined. So I trust everyone is happy with the way we've done that. If not, if anything's unclear, perhaps just stop me and we can explain a bit further. And then the following important thing I just want to note is, and I think you've raised this before, Chairperson, is, I mean, this is quite a complex bill, which proposes amendments to several environmental pieces of legislation. So although we give our proposals in this document, we do advise that these proposals also be discussed and debated with our colleagues at the National Department as the drafters of the bill, just to assess any potential unintended consequences or further consequential amendments that might be needed from what we propose below. I trust that you will consider this suggestion. Then perhaps if there's no questions on what I've just said, we will then go to the specific clauses as requested by yourselves. I'm going to start with clause 5 of the bill. This was in fact, I think, an issue that was flagged at a previous engagement. We were requested, the department was requested to come up with proposed wording amending clause 5 of the bill, which deals with applications for rectification. So perhaps just to reiterate our comment. The comment we made was, it is proposed that the environmental management program requirement should be a separate requirement and not included as part of section 24G1C2 AA report directive. The requirements to compile an environmental management program should be a separate requirement captured in a new and separate provision under section 24G. So I think everyone was in favor of this proposal, and therefore you made a request to us to actually come up with how the clause, or to compile such a clause, which we've done. I'm not sure whether you would like me to go through the exact clause, but if you scroll down to the document, you will see what we've done. Again, just to reiterate, that through is where we propose a deletion in what is proposed in the bill, and then the bold and underline is where we propose an insertion. Perhaps we can just get feedback from the members whether they are happy with this proposal in terms of clause 5.
Members, I don't think you've had an opportunity to really read through it. So even if it's just for this one, so that we can just be all on the same page, won't you just quickly take us through the clause?
I can just go back to I seem to have lost my document. Just a moment. Okay. Sorry, Chairperson, we are on mute. You've asked us to take you through the clause. Is that correct? Okay.
Yes,
Sorry, that is correct. That is correct. It is a fairly long clause.
Okay. So first of all, I'm going to perhaps then go to the bill. So clause 5 of the bill, which deals with, as I said, rectification applications. It is quite a long clause, Chairperson, so I'm going to start at the top and just go through the clause. I'm only going to go through 5 sub C, if that's
in order. That is in order.
Okay. So 5C currently provides that by the substitution in subsection 1 for paragraph B of the following paragraphs, and then C inserts, is in control of or successor entitled to land on which a person, and then Roman numeral 1, has commenced with a listed or specified activity without an environmental authorization in contravention of section 24F subsection 1, Roman numeral 2, has commenced with, undertaken or conducted a waste management activity in contravention of section 20 sub E of the National Environmental Management Waste Act 2008. The minister responsible for mineral resources, or MEC concerned, as the case may be, in proposed deletion of may, must direct the applicant immediately cease the activity pending a decision on the application submitted in terms of this subsection, except if there are reasonable grounds to believe the cessation will result in serious harm to the environment. Investigate, evaluate, and assess the impact of the activity on the environment, remedy any adverse effects of the activity on the environment, cease, modify, or control any act, activity, process, or omission causing pollution or environmental degradation, contain or prevent the movement of pollution or degradation of the environment, eliminate any source of pollution or degradation, compile a report containing, and then it goes into double AA, a description of the need and desirability of the activity, an assessment of the nature, extent, duration, and significance of the consequences for or impacts on the environment of the activity, including the cumulative effects and the manner in which the geographical, physical, biological, social, economic, and cultural aspects of the environment may be affected by the proposed activity, a description of mitigation measures undertaken or to be undertaken in respect of the consequences for or impacts on the environment of the activity, a description of the public participation process followed during the course of compiling the report, including all comments received from interested and affected parties, and indication of how the issues raised have been addressed, if applicable. And I think here is where the changes we make comes into play. So we then propose deleting the paragraph EE, which is, I think, line 61 of the bill. So we propose deleting that and then inserting a new subsection capital H to read undertake public participation as prescribed, and then to make a new insertion again. They may direct the act to with provide such state minister responsible for mineral resources or MEC, as the case may be, may deem necessary. And then we further propose, as you will see from the document, a new inserted subsection CC, which reads may direct
Thank you.
the
Honourable member,
engagement.
Mr. Rousseau, my apologies. You have gone completely silent on my side from time to time, and I'm not sure if it's my connection or whether it's yours. Perhaps some of the other participants in the meeting can just give me an indication. Is it only on my side that you were breaking up?
No, it's not only you, Chair, also from my side.
It was fine on my side.
Sure. Okay. Okay, because the last thing I want for us is to struggle today with connectivity as well. Okay. So sorry, Ms. Nika, thank you very much. And I do hope that for the remainder, we wouldn't expect of you to go through the full clause. But can I just ask the motivation for this change?
Chairperson, yes, just one line, please. The one, please.
Chair, Paul Hardcastle, maybe I can just also highlight
Yes.
that, sorry, we're just trying to, we're sitting in the same room and we have to just to figure out how to deal with all the echoes also. What I want to highlight is that the need for an environmental management program is not always necessary, and you don't want to also direct a person to immediately compile an environmental management program. That's why we want to separate it out as an additional provision that you may direct a person to compile an environmental management program that is not automatically done with everything else.
Good. Thank you very much for that. And I think it makes sense, honourable members. Can we therefore include that in our mandate? Thank you. Yes. Can you please then go on to your next paragraph? Is it again Ms. Rousseau that's going to present that?
Thanks, Chair. I will then continue with the next one, that is clause 4. I just want to say the department was requested to consider the adequacy of the national response to the concerns expressed regarding the National Environmental Management Biodiversity Act and Section 1 definition of control. That's page 50 of the matrix. That's a control of alien and invasives and so on. So Also, that Member Bartman requested the department to consider the deletion of the reference to the whole of the Republic in that definition. Then we've gone through National's response, and in short, and we didn't go through all of the explanations and so on. The explanation by National is quite logic. And we are satisfied that the explanation provided by National Department clarifies the wording of the definition of control. Based on the explanations given, it is proposed that the definition be further amended by adding words planned and over time to the definition. But Chair, just to highlight, even that is sometimes we can add those words, but somebody else can interpret that even in a different way. So, but be as it may, we have proposed that, and also the reference to the whole of the Republic is adequately explained, and we believe that it should be retained. So based on all of that, we propose therefore that the definition be reads as follows. And you again see that what we've done is added in bold, underline the word planned and over time to hopefully more explain the meaning of systematic. Systematic means that you plan to do something over extended period of time. But again, that is a proposal on the table. And we would like to see if the members agree with that it may clarify the definition of control better. And yeah, so that is in essence what we're proposing as part of clarifying the word control.
Thank you, honourable members. Are you happy to accept that?
Chairperson Deirdre Bartman.
Please go ahead.
Chair, I support the department's proposed amendments.
Thank you very much. Can we then move on to the next clause?
Okay, Chair, then the next clause is clause 49B, and that is the amendment of section 99 of the National Environmental Management Biodiversity Act. It's page 52 of the matrix. And the department was requested to consider National's response to the comments of the Western Cape. Now, the Western Cape comments stated the following. This clause amends the introductory paragraph of section 99.2 of NEMBA. It is currently, in its current form, the clause requires that the MEC for Environmental Affairs must inter alia consult with cabinet members whose area of responsibility may be affected by the exercise of powers in terms of this Principal Act. It is submitted that the MEC would exercise its powers at the provincial level. It's therefore not clear why the MEC must rather consult cabinet members whose areas of responsibility may be affected by the exercise of power. It is submitted that the MEC should consult the members of the Provincial Executive Council, whose areas of responsibility may be affected by the exercise of the power. Now, National agreed with that, and in fact, they then proposed a new clause. So that clause is now also included in our proposal. So we accept and we support what National have proposed themselves to be an added clause that they differentiate between the minister exercising, the ministers need to consult with National Cabinet members versus the MEC's responsibility to consult with provincial members of the Executive Council. So that added clause to big A is then the proposed amendment, what was actually proposed by National, and we support that. So yeah, I don't know if there's any comments on that, but it seems that there's a concurrence from National also.
Thank you very much, Mr. Hardcastle. Honourable members, can we agree to that proposal as well?
Chairperson, Deirdre Bartman, support.
Yes, thank you. And then, honourable members, and also others on this, please, if I do start speaking while you are on, it seems to me as if my line is not good, and from time to time you do go silent, but especially when you're reading from the document, I'm able to pick up where you are. But my apologies if you find that I interrupt you while you may be speaking or addressing us. Thank you. So, Mr. Hardcastle, are you also going to deal with the next clause?
Mr. Chair,
Yes,
before Mr. Hardcastle starts, the document which he is displaying is the document which we submitted this morning. Apologies for being delayed, but it was quite complex. And if you just follow what is on the screen there, we're referring to the clause which was referred to us, and then the page on the matrix, and then we go into the discussion. So the document is quite comprehensive in terms of contextualizing the amendments that we're making based on the historical experience that we had with the committee. So we'll follow this formulation as we go along. So you do have the clause number, you have the page in the matrix, and you have the referencing in terms of the precise clauses within the legislation, what the act says, and then what our response was, what the national response was, and what our conclusion is. So that's just to contextualize the document which is in front of you. Thank you, Chair.
Thank you. Can I just ask again, who's going to deal with this clause?
Mr. Hardcastle will proceed.
Thank you, Mr. Mohammed. Please proceed.
Thank you, Chair. The next one is point 4. It's dealing with clause 53C. It's on page 58 of the matrix. Just by the way, that in the matrix, the incorrect reference to clause 53A, section 36(2) big A, must be changed to clause 53C, section 36(8) of NEM-AQUA. The department was requested to consider SALGA's submission on the issue and if there's any amendments proposed. And what we did there highlighted is just what section 36(5)(c) is doing, and that is basically notwithstanding any subsections 1 to 4, the minister, meaning a national minister, is the licensing authority that must perform the functions of a licensing authority if, and then there's 3 circumstances. If one, a provincial organ of state which has been delegated the power to perform a licensing authority, and then secondly, if the listing authority falls across boundaries of one province, across the boundary of a province, and then importantly C, the listed activity form part of a matter declared as a national priority in terms of a cabinet decision and notice referred to in section 24C 2 big B of Nema, or the Nema Amendment Act. Okay. The Western Cape's comment recommended the following: that it's recommended that section 36(5)(c) of AQUA is deleted. That's the one that if it's a national priority, then national will be the competent authority. This will allow the district or metropolitan municipalities to be the licensing authority even on matters of national priority, but will still allow the minister and the licensing authority to reach an agreement based on the fact that a specific matter, specific application for the minister to become the competent authority. That's in contrast with a blanket assumption that district or metropolitan municipalities cannot adequately deal with such applications of national importance. The alternative proposal, but which is not the preferred option for us, is that NEM-AQUA be expanded to include subsection 5 and therefore allow for agreement between the minister and the MEC and all municipalities for matters of national priority. And this is actually what is proposed in the bill. So, Chair, let me just quickly confirm, because we believe that air quality is of a provincial, is a local mandate, we believe that the first port of call should be a municipality. And if necessary, there can be agreement with province or national. However, what is currently in the bill is that the national minister will be the competent authority, but it does allow for an agreement with the with province or municipalities that they can become the competent authority. SALGA's response was, in short, is this: the suggestion that Section 36(5)(c) of AQUA be deleted in order to allow district and metropolitan municipalities to be the licensing authority pertaining to air pollution, and that's important distinction between air pollution and air pollution control, is sound. It is clear that the Constitution intended this to be an exclusive local government competency. National government stated the following: the proposed amendment to Section 36(8) includes the reference to subsection 5, which allow for an agreement to be reached between a minister as has been identified as the competent authority for national priorities. This will allow either a province or municipality to be the competent authority. Sorry, that's not LH, it should be CA, competent authority. National priorities are identified by Cabinet as set out in Section 24C to Big B of Nema. The same ability to reach an agreement has been incorporated in the proposed amendments to Section 24C of the bill. In summary, whilst SALGA agrees with the Western Cape proposal to delete Section 36(5)(c) to allow district and metropolitan municipalities to be licensing authority, national government does not support such a proposal. And hence, what is currently in the bill, Chair, is that although by default national government will be the competent authority, but there is a possibility of agreement with provinces and municipalities. Our first prize was by default municipalities should be the licensing authority with an ability to have an agreement between with provinces or national. So we did not make any proposal because I think government and national will probably stand very firm on this one, but that in essence is what it is. And so we did make a proposal. So currently the bill makes national the competent authority, but we can agree that provinces or municipalities become the competent authority. Any comments on that, maybe?
Can I just ask, before I give over to the members to also add their questions, it seems to be then that as if this may be a constitutional difference in that we believe that this is a constitutionally determined prerogative of the local government, whereas it seems as if the proposals from national wants to take that competence away from local government unless an agreement has been entered into. Honourable members, are there any other questions? Any other members that would like to ask questions or comment on this?
No, Chair.
Honourable Maseko, you're happy?
Yes, Chair, I'm happy with everything.
Chairperson?
Honourable, sorry, Ms. Nika?
Shireen. May I just point out to you that we have representatives from SALGA present in the meeting. We have Mr. Kutsia, Mr. Mpela, and Mr. Jamela present as well. And I see Mr. Kutsia has just raised his hand.
Thank you. Over to you, Mr. Kutsia.
Thank you, Chairperson. Can you hear me?
We hear you far better than earlier today.
Yeah, this morning I had it seems to me the problem was with my computer. I've got a new one now. Chairperson,
Please proceed.
thank you very much. The important thing here is, as stated by my colleague just now, it's a distinction between pollution control and air pollution. Air pollution is clearly defined in Schedule 4, Part B of the Constitution as an exclusive local government competency. For national to want to usurp that function is clearly unconstitutional. And I think that this committee should send a clear message to the NCOP to bring this to their attention, because national and provincial can deal with pollution control, and they can enter into the agreements between the two of them when it comes to pollution control, but they cannot take over air pollution. It's an exclusive local government competency. And in this regard, we agree with Province that Section 36, subsection 5C should be deleted. Thank you very much.
Thank you, honourable members. Any other questions or views? None. Can I then ask Ms. Niekerk, you would then be able to get from this what needs to be included in the negotiating mandate or the document that we will be forwarding to the NCOP?
That's correct, Chairperson. I'll do that. There is a draft available as we speak.
Good. Thank you very much. Then again, back to the officials from Department of Environmental Affairs and Development Planning, who will be dealing with the next clause.
Thanks, Chair. Again, Paul Hardcastle here. We now with point 5, and that's a proposed new clause, and it's again the proposal is to amend section 37 of Nema, page 61 of the matrix. And the department was requested to propose a wording that to include a may option where best suited, and to add an additional clause, section 36 to section 46 of Nema. Now, just maybe highlight, and I see that it's maybe not clear from that introductory paragraph, and that's dealing with the verification of provisional atmospheric emission licenses. So this whole clause deals with that. The Western Cape's comment was as follows. An application for a variation of an atmospheric emission license triggers the need for a basic assessment process in terms of the impact assessment regulations, with specialist studies required in certain circumstances. The processing of a variation application requires a great deal of engagement with an EEP, and the process often takes quite a considerable time and effort. It is therefore proposed that Nema is amended to require that an application for variation of an atmospheric emission license must be accompanied by a payment of an application, payment of a processing fee. National government supported the recommendation and requested that only section 46 should be amended, and then based on that, we propose therefore that section 46(2)(d) be amended, and where the section refers to a written request, that word on a written request be substituted by on application, and the same in subsection 3 on application. Then we insert after sections 2 a new in bold underlined section to say that an application for variation of an provisional atmospheric emission license from the holder of a municipality from a license contemplated in subsection 1D must be lodged with the licensing authority in an area in which the listed activity is or is to be carried out. in a form required by licensing authority, and then an application contemplated in 1D must be accompanied by the payment of and prescribed processing fee and such documentation and information as may be required by the licensing authority. That's, in other words, what we've done is the 2 big B, subsection 2 big B that was added, is to also bring it in the context that it is based on a payment of a processing fee, and the wording is consistent with the wording we used in the rest of the of NEM Aqua, where there's an application to be lodged.
Good, thank you very much, honourable members. Does that carry our support? I take silence as
Yes.
confirmation. Thank you very much. Then again, back to you, Mr. Hardcastle.
Thank you, Chair. Then the next, we move to point 6, or paragraph 6. And this is again a proposed new clause. The proposed amendment of section 41 of NEM Aqua, and that's page 62 of the matrix. And we requested to propose a specific wording for page 64 of the matrix. The Western Cape's comments. Section 41.3 of NEM Aqua provides that a provisional atmospheric emission license is valid for a period of 1 year from the date of the commissioning of a listed activity, and may be extended for an additional 1 year period on good cause shown to the licensing authority. However, section 42.1 of NEM Aqua provides that the holder of a provisional atmospheric emission license is entitled to an atmospheric emission license when the facility has been in full compliance with the conditions and requirements of the provisional atmospheric emission license for a continued period of at least 6 months. It is submitted that the licensing authority should be empowered to determine the period of extension of a provisional atmospheric emission license. This will resolve the practical difficulty faced by licensing authority. In other words, sometimes testing and the studies done, it takes quite an extensive amount of time, and it's not necessary that's possibly to be done within a year. National's response was as follows. The proposal by the Western Cape is not supported. This proposal will empower the licensing authority to issue a provisional license that can be renewed endlessly, which is not intended to be allowed. An atmospheric emission license cannot be issued to a facility that failed to demonstrate compliance with the minimum emission standards. While it's understood that it may take some time for a plant to operate as it was intended during the design, a 2-year period is long enough to illustrate compliance with the law. Now, based on above, we obviously believe that there's still a practical problem, and to overcome their concern about the endlessly renewing it, the proposal is in subsection 3 that we delete the reference to an additional 1 year, but then we add the word once for a period determined by the licensing authority, which creates more flexibility so that based on the circumstances on the ground, you can then determine the period, which even may be, by the way, shorter. It doesn't need to be longer than a year, but it can even be shorter. But it creates more flexibility with the competent authority.
Good, thank you. Honourable members, any comment on that? And again, I take silence as support. Mr. Hardcastle, will you proceed?
Chair, Anique will take the rest now.
Thank you.
Okay, thank you, Chair. Can everyone hear me? Just perhaps. Okay. So I'm moving on to item 7 in the document, which is also a proposed new clause. That is a proposal we made in our comments to section 1 to 6 of Nema, and that is on page 48 of the matrix. And the department was requested to provide proposed wording to address the comment we raised regarding the potential inclusion of the municipal council as an appeal authority in the Nema appeal provision. So just to reiterate the Western Cape government's comment, municipalities are empowered to issue directives. This constitutes a decision. Provision should therefore be made for an appeal against such a decision to the appropriate organ of state. It is proposed that provision be made that a municipal council may decide an appeal in terms of section 43(1) to 6 where appropriate. And we discussed this at our previous engagement, and we were requested to make a suggestion in terms of how to address the concern. I first just want to go, so the National Department responded, comment, and indicated that this is already provided for in clause 34 of the amendment, which adds the municipal council as an appeal authority for section 28 directives issued by the municipal manager. Now, we believe that this, however, it does not provide in terms of whether an appeal to the municipal council should be made in terms of section 62 of the Municipal Systems Act, or in terms of the national appeal regulations promulgated in terms of NEMA. So without going into too much detail in terms of the Systems Act versus the NEMA appeal process, obviously there's two different appeal processes. One in terms of section 62 of the MSA, which provides a generic appeal process for where a municipality made a decision. And then there's the more specific NEMA national appeal regulations for decisions made in terms of NEMA and the CEMAs. And we strongly believe that the current uncertainty in terms of which process must be followed must be clarified. And in this regard, we also would like to refer the committee to the comments made by the CER, which I will just quickly note here. Since the amendments contemplated are intended to bring appeals of decisions made by municipal licensing authorities in terms of the Air Quality Act under the ambit of NEMA's section 43, which is the NEMA appeal provision, required to include a reference to the new provision in section 43(4) and to the municipal appeal authorities in terms of section 43(5) and also 43(6), which is what we're going to propose just now. And just maybe to also note that National, in fact, in their response to CER's comment, confirmed that this will, in fact, be considered. So I'm going to move on to just to confirm again that the department supports the view that that any appeal in terms of a decision made under NEMA should be dealt with in terms of the NEMA appeal regulations. So our proposed amendment is in aiming to clarify this, that this appeal to the municipal council for a decision taken by the municipal manager must be dealt with in terms of the NEMA appeal regulations. So what we suggest is a proposed amendment, which is obviously this section is not currently included in the bill, so it's a new proposed amendment to the current section 43, subsection 4 of NEMA. So subsection 4, we propose to read an appeal under subsection 1 capital A, and we propose the insertion of 1 capital C, 2, and we propose the insertion of or subsection 8 must be dealt with in the manner prescribed upon payment of a prescribed fee. With regard to subsection 5, we propose it to read the minister, an MEC or municipal council, as the case may be, may consider and decide an appeal or appoint an appeal panel to consider and advise the minister, an MEC or the municipal council on the appeal. And then subsection 6 . 6 . 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. Section 6, or the catering set aside or directive or make any other appropriate decision, including a decision that the prescribed fee be paid by the appellant or any part thereof be refunded. And that is what we propose in terms of Section 43 of Nema, which is the appeal provision.
Again, honourable members, any comment on that? Or can we, Mr. Coetzee, Anton Coetzee, I see your hand.
Thank you, Chairperson. Salgo's view is slightly different than what was just carried out by Province. We do not understand why the current appeal procedure in terms of Section 62 of the Systems Act should be duplicated. It creates a lot of confusion, and this is also something that has exercised legal minds for some time in the past. When you will remember at the time, Chairperson, when you were still a speaker, and council considered Lupo applications, there was an appeal procedure in terms of Section 44 of Lupo, and there was the parallel appeal procedure in terms of Section 62 of the Systems Act. This matter ended up in court, and it was then decided that after the decision was taken by a municipal official in terms of delegated authority, that decision will only become final after the appeal. So the Section 44 appeal of Lupo will only become ripe after the internal remedies have been exhausted. Why we want to, well, this situation was luckily then sorted out later with the new town planning laws, but why we want to duplicate this whole mess that we had in the past, why we want to duplicate it again, I simply do not understand. We have an adequate Section 62 appeal procedure in government. There is some case law on it. It's been exercised. We know how it works. I don't understand why you want to duplicate it. The other thing that we want to mention is if you do want to include an appeal procedure, you need to deal with the vesting of rights. So in other words, once a decision is taken, the rights has to be suspended pending the appeal. And therefore, it is very important that you state in the Act that an appeal must be submitted within a specific time frame, failing which the decision will become final. So then also in the Act, you deal with the minister or the council as the appeal authority. I don't understand why we want to make it so difficult. We've got enough laws in local government that governs our conduct. We would suggest that you allow municipalities to exercise their autonomous identity and deal with their own matters. Thank you, Chairperson.
Thank you, Mr. Coetzee. I recognize Mr. Mohammed.
Thank you, Chair. If I may respond, and then I can ask my team also to respond. Firstly, this is a directive, which is not a vesting of rights. So it's very different to the planning decisions that we are talking about, or any authorization that is giving rights. This is in response to a detrimental damage to the environment. So it's a power that is being given to municipalities to respond, to act when there's environmental harm or environmental damage. But because of PAJA, there's always an appeal against that action of the municipality. So that is the context of this appeal. It's very different to the context which was sketched earlier on by Mr. Coetzee. Now, in terms of the planning dispensation, the statements was all correct, except that under SPLUMA, which is now the Spatial Planning and Land Use Management Act, which dictates planning decisions at municipality, they have also excluded the MSA 62 appeal. So there is an evolution of the legislation that specific line-specific legislation will be dealt with within the context of that legislation. So the Spatial Planning and Land Use Management Act also then states that no appeal in terms of the MSA 62 is allowed, and that appeals must be dealt with in terms of the provisions of the Spatial Planning and Land Use Management Act. Now, what we are also saying is that if we apply the appeal regulations, which was quoted earlier on, because the appeal is in terms of Nema, and the appeal regulations give the meat and the flesh to the way the appeal can be administered, then we are consistent also with the CER's view and with the rest of the Nema regime that the appeal will be dealt with in terms of the National Environmental Management Act and not a separate act, which is the MSA 62, because that is a different appeal procedure. So our stance is that that the appeal should be dealt with in terms of this directive scenario. It must be dealt with within the Nema regime and the Nema appeal regulations, which is commonly understood and which is practiced widely within the environmental regime. So just again, it's not a decision that is giving rights. It's actually an action of the municipality to stop environmental harm, and that is what the purpose of the directive is. Thank you, sir.
Thank you, Mr. Mohammed. Honourable members, we have now heard various opinions on this matter. I'm not so sure if I don't feel myself well equipped to be able to take a final position on this just now. Can I ask the Honourable Advocate Bartman to please, I recognize you.
Chair, I was actually going to propose that we support the suggestion as per the department. Thank you.
Good. Any other positions on here? Thank you, Kenna.
Chair.
Yes, good. Thank you, Honourable Maseku. Perhaps, Honourable members, I'm going to ask that we move on to paragraph 8, and I do intend for us to take a little bit of time out a little bit later on during this meeting for a break, and also for us to be able to prepare ourselves in terms of the documentation that we need to consider. And perhaps Mr. Kutsia and our provincial colleagues would be able to just discuss this offline and see if they can't come to some form of agreement on that one, having heard the others' views on that. Again, Honourable Bartman, I recognize you.
Thank you, Chair. Chair, we have 2 pages of the current document left over. And if I remember correct, majority of the NEMLA stuff we've already dealt with. And I think there's very few that we haven't dealt with. And if we are able to finish it, then we might even be able to finish a little bit earlier instead of taking a break. But that is just a suggestion. Thank you, Chair.
Good, thank you, Honourable Bartman. I am absolutely impressed by by your positive expectations that we would be able to finish with this earlier, when I initially thought that we might even be needing more time than what is allowed for our meeting today. But thank you. We will certainly try to see how far we can come. Next one is then paragraph 8 be presented to us.
Yes, Chairperson, Anik Rousseau. So paragraph 8 deals with clause 62 of the bill, which proposes an amendment to section 34 capital F subsections D, F, G and H of the National Environmental Management Waste Act. And you will find that on page 70 of the matrix. And the department was requested to make a proposal on where we see a provision suggested by the National Department in their response, where we see that provision could be inserted. At the last engagement, Chair, you also noted section 34 capital A subsection 2 of NEMWA, which is not part of the bill, but does in fact appear to address the concern raised. So let me just first of all just reiterate the Western Cape government's initial concern. It is admitted that the paragraphs of this clause should expressly be made subject to the Public Finance Management Act of 1999. And just maybe to say that this deals with the establishment of the National Waste Bureau. The comment continued, it is proposed that it is expressly provided that the provisions of the new proposed sections 34, capital F, D, F, G, and H are subject to the Public Finance Management Act. Apologies for that. And this was in fact a comment from our Provincial Treasury Department, and the National Department responded to the comment as follows. The PFMA will apply to the extent that it applies to public entities. However, to make it clear, one may consider adding the following wording. The Bureau is a public entity for the purposes of the Public Finance Management Act and must comply with the provisions of that Act. So once again, after we had a look at Section 34, capital A, subsection 2 of Nema, which provides that the Bureau must comply with the provisions of the Public Finance Management Act 1999, it does appear that our concern has in fact been addressed, and Nema currently does specifically provide that the Bureau is subject to the PFMA. So I think we've reconsidered the comment and we think it has been addressed, or it doesn't need to be addressed any further.
Thank you, Ms. Rousseau, and I agree with that view of yours. Honourable members, can we then move on to paragraph 9? Thank you.
Chair, paragraph 9 deals with clause 64 of the bill, and it proposes the amending of section 36 subsection 5 of the Waste Act. Now this and the following clause 65 deals with contaminated land, and it's actually comments made by the Centre for Environmental Rights that you specifically raised at the last engagement and requested the department to have a look at CER's comments and make a proposal in terms of how and if they should be taken forward. This can be found on page 82 and 83 of the matrix. We had a look at the comments made by the Centre for Environmental Rights, and perhaps I'll just read the comment made. So the comments from CER on page 82 of the matrix noted as followed. In relation to proposed amendments to contaminated land provisions, we note that there are still gaps and arbitrary ambiguities in the proposed amendments. It is not clear why a person undertaking activities on land has a higher threshold for notification than an owner, in whose case there must merely be a likelihood of contamination. And in the National Department's response, they agreed that the emphasis on who needs to report on likely contaminated land must be the same for either the user of a land or the owner of land. And they therefore agree with CER's comment. So again, we had a look at what CER proposed. We are in agreement to make the following amendment to clause 64, which amends section 36.5 of Nema. An owner of the land that is likely to be contaminated, or a person who undertakes an activity on land that has likely caused the land to be contaminated, must notify the Minister and MEC of that contamination or potential contamination as soon as that person becomes aware of that contamination or potential contamination. So again, we confirm we support this proposal from the CER to have the same onus on both the owner as well as the person in control of the land. Would you like me to move on to the next clause, Chairperson, or first discuss this one?
Perhaps. Thank you, Mr. Rousseau. Again, unfortunately, you broke up on my side, but from my side, I can just say I appreciate this wording. I think it, to my mind, it states far more clearly what I think was intended by the original proposed clause.
Okay, Chairperson, I'm going to move on then to clause 64, if that's in order. Clause 65, I mean, that's paragraph 10. So
you.
clause 65, which amends section 37, subsection 1 and 2 of NEMWA. Again, it was a comment from the Centre for Environmental Rights, and it's contained on page 83 of the matrix. The department was requested to have a look at CER's concern and also confirm proposed wording to resolve the issue. And having looked at CER's concern and the comment, we confirm the support of the proposed proposal. So paragraph 37, subsection 1, subsection A, we propose to read as follows: require a site assessment to be conducted in respect of the relevant investigation area, and that a site assessment report and remediation plan, if applicable, be submitted to the Minister or the MEC as the case may be, within a period specified in the notice, which cannot be more days. Just to raise to the fact that the clause was attached to the submission of the report. And we believe that the amendments we've clarified both.
Thank you, Mr. So, honourable members, can we therefore move on with your support to this proposed amendment? Thank you.
Support, Chair.
I believe we will now be on paragraph 11 then. Is it just me that's not hearing Ms. Rousseau, who will be dealing with paragraph 11?
No, there's no sound, Chair.
Thank you. Thank you. And at least I'm not alone in not hearing.
Can you hear me?
You are breaking up. You are breaking up, Ms. Rousseau. My understanding is that you and Mr. Hardcastle are actually sitting in the same room, yet it seems to me we could hear him better than was the case with your computer.
Oh, I do apologize.
No, I do know this is outside of our control. Are you going to present paragraph 11 to us as well?
Yes, if you can maybe, if I break up again, then I'll stop and I will pass on to Mr. Hardcastle, perhaps, if I continue to break up. Okay, so then the proposed new clause, which is paragraph 11, deals with section 54 of the Waste Act, and that can be found on page 71 of the matrix. And we were requested to consider the National Department's response to the comment made by the Western Cape government. And the comment we made was as follows: we requested clarity is required as to what the effect of the non-payment fee of a prescribed application fee, and the department responded, the National Department responded as follows: the requirement for variation application includes the payment of the prescribed fee. In the event of non-payment, application for variation will not be processed as it does not meet the requirements. And we confirm that we are satisfied with the explanation as provided for by the National Department, and it does clarify, and we agree with that. So I think we've reconsidered the comment as National has provided the required clarity.
Thank you. And your sound is suddenly much better, and it means that members, we can then support the clause as originally proposed and adopted by the National Assembly, which brings us to paragraph 12.
Chair, Paul Hardcastle, I will deal with that clause. This is amending section 12 of the National Environmental Management Amendment Act.
Mr. Hardcastle, won't you just quickly mute your colleague there?
Just hang on quickly. Yeah, muted. Ze took your klank off. Okay, sorry. Okay. Yeah, it's quite yeah, sorry. Okay. Yeah, clause 82, and that is dealing with section 12 of the National Environmental Management Amendment Act of 2008, and that's dealing with transitional arrangements. And that is forthcoming from this whole new one environmental system, and this whole transition of trying to pull mining under the Nema dispensation, and it's trying to deal with all of the transitional challenges of implementing this one environmental system. Now, one of the ongoing debates was actually on how do you deal with this interplay between an environmental management program that has been approved in terms of the mining legislation compared to the requirements for authorization in terms of the environmental dispensation and its associated associated environmental management programs that is part and parcel of every application for authorization. Now, one of the concerns we always had in the interpretation of this clause was, and this was, by the way, also the concern raised by CER, is that the clause is very unclear on this relationship between an EMPR and an there's an environmental management plan and an environmental authorization. An environmental authorization follows a detailed EIA process, whereas an environmental management plan constitutes the implementation of the management measures following an EIA process. So we were very concerned because for a long time it was mooted that to deal with this transition, you have to convert all environmental management programs under the mining dispensations to automatically become an environmental authorization. We were highly concerned about this and say that you cannot convert an EMPR to be an environmental authorization, and wanted clarity that this provision is not saying that. National, and we raised that concern as well as CER raised that concern and said that the clause nor the objects of the bill clarified this concern, and that is not the case. The National's reply to CER was that it is not the intention, and an EMPR is only an EMPR in terms of the mining dispensation will only be an EMPR in terms of the environmental dispensation. It is not deemed to be an authorization. So that said, therefore, this clause needs to be redrafted. And that's where we believe that I'm very hesitant, and as colleagues, my colleagues, we are very hesitant to propose a specific wording, because we need to really thoroughly debate this issue with national government, so that we do not have unintended consequences, and we make it very clear that the relationship is the correct relationship. So at this moment in time, Chair, we don't have a specific wording other than being very glad that National at least confirmed that the intention is not to convert a management plan into an environmental authorization. But how we redraft this clause to clarify that, well, I think this needs to be further debated. I think what we can highlight I cannot dictate to you what you want to do, but we can maybe highlight that National actually do reply to CER and say that yes, clarity can be provided, and the intention is not to convert EMPRs into EAs, environmental authorizations, that is. But that a clause must be redrafted to clarify this and to avoid any interpretational challenges.
Good, thank you very much. Obviously, that makes it a little bit difficult for our representatives in the NCOP to be able to present something there, but can I say for now that we note this and that this doesn't need to be probably the final communication. There could still be informal communication with our representatives in the NCOP, and that this matter be then taken up with them in that way. Honourable Bartman, you're recognised.
Thank you, Chair. Chair, in lieu of the fact that there isn't a proposal for the wording for this particular clause, I would like to then propose that the original wording submitted by the department as a comment on the clause then be submitted to the NCOP accordingly.
Thank you. Thank you, Honourable Bartman. Perhaps I can just ask at this stage if Advocate Marsdorp would like to respond.
Chairperson, we have Advocate Leroux present for this amendment bill.
Oh, for the NEMLA. Yes,
Yes,
thank you, Advocate
yes.
Leroux.
Chairperson, I have no comments. Are you asking on this specific issue or in general?
No, on this specific issue, Advocate.
No, Chairperson, I have no comments.
Good. I accept that this also must have come down a little bit quickly. But okay, so in terms of clause 82, I think we know that that one needs some further attention. And as I've said, if we cannot finalize that today, then perhaps informally between colleagues of Provincial and National, this is a matter that could be dealt with. I almost want to say in parallel ways, still working towards the same good end result. Then Honourable Bartman again.
Chair, thank you. I just want to clarify. The proposal that I made for the comment to be submitted on this clause, the original one, I don't want it to be submitted informally. I would like the comment to be submitted, the original one, as part of the negotiating mandate. That was my proposal. Thank you.
Good. No, thank you, Honourable Bartman. And I think I think what we've just heard is that it's absolutely correct to highlight this. It is a matter that needs further attention or needs to be clarified. And yes, we can include that formally, that there is still, can I call it, work to be done in terms of this particular clause. So please, if we move on to the consideration of the final mandate, please, if you particularly being the one raising this, if you could help us just or remind us of the importance of this specific clause. Thank you very much. Can I ask, is this the end of the document from Environmental Affairs and Development Planning?
Yes, Chair, that is everything that we have submitted. I don't know if there's any outstanding issues that Ms. van der Kerk and Ms. Niekerk can highlight, but this is the complete document.
Good. Thank you, Mr. Hardcastle, and thank you very much for all the hard work that you had put in to prepare this document for us. Honourable members, I'm going to propose that we take a brief break of 10 minutes. Can I just ask before we leave that Ms. Niekerk just give us an indication of how best she believes we would be able to deal with the mandate after the break, because she did indicate that she's got a document prepared that might assist us in going forward. So Ms. Niekerk, if you could just tell us what can we expect then after a 10-minute break when we come back?
All right, Chairperson. I've compiled a draft report containing the proposals that was just made by the department because I was fortunate to receive some of them last night already. They were still in a draft format though. But just to that the committee remembers that what the department presented now deals with clause 33 to 82 of the amendment bill. Previously in a committee meeting, the committee meeting of 25 August, the committee agreed to certain proposals that would be sent through to the NCOP Select Committee on clauses 1 to 32. So I have a draft document prepared. I could maybe just put that on the screen and the committee can agree if the proposed amendments included in the report is acceptable. But in essence, the proposed amendments are the resolutions that were agreed to by the committee. All right.
Ms. Nikak, and you've already, I almost want to say, incorporated the deliberations of that earlier meeting of us also in the same document that you would be able to beam onto our screens.
Yes, it's all been included as well as what the department has just presented now, but it is draft and I just have to double check that it's exactly the same as what the committee agreed to in this meeting.
Thank you. Honourable Member. Heron, I recognise you.
Thanks, Chairman. Just before we break and maybe the department leaves, the section, I think it was the paragraph 7 in the document which dealt with the appeals. We kind of parked that and said we would come back to it. So I'm just, how are we going to come back to it if the department leaves, and how are we going to engage with that particular clause?
No, thank you. Thank you for raising that, Honourable Heron. My proposal was that the department, as well as the representatives of SALGA, perhaps while we take a brief body break, liaise with one another. I do hope that neither of them will leave this meeting and that they will still be able to support us in our deliberations or consideration of the draft document that we are going to see soon. But that hopefully when we get to that specific paragraph, that by then between them they would have been able to come to some form of agreement. Obviously, if they're not able to, what I heard from the honourable members was that they that they tend to support the department's recommendation, but I would have liked the department just to engage with SALGA, because obviously local government is an important role player, and I think, you know, in certain respects, especially when it comes to air quality, they are the constitutionally mandated authority, and therefore I just think it would add value for us and for the process going forward to give serious consideration of their input and their views on this. Mr. Coetzee, I see your hand.
Chairperson, we don't need to engage much on this. I've heard the sentiments of the provincial department. I think what you need to do, and I do accept that there is a tendency to have parallel appeal committees or procedures. But I think what we need to do then here is, if we go with the appeal in terms of this act, we need to state in a similar vein as section 50 of LUPO, that section 62 of the system.
Sorry, Mr. You are breaking up again.
Okay, I'm not sure why that is.
Why? I heard you quite well when you up to the point where you said that there is a tendency to run with parallel appeal processes, but thereafter I lost you. So if you would be able to either repeat that, or perhaps if you could put it in the chat box.
No, I tried this morning the chat box, but I was disqualified from using that, so I haven't tried this one. Can you hear me now?
I hear you. Thank you.
What I'm basically saying is, it seems to me there is a tendency to provide for appeal procedures, not necessarily as a parallel appeal procedure, but a different one to the domestic appeal in local government. But I think what we need to do then is just follow the same pattern as in Section 50 of LUPO, and make it absolutely clear that Section 62 is not available as an appeal procedure in terms of this Act. And that would solve the problem. Thanks.
Thank you. I see a number of hands. Can I just, on this specific topic, first ask for Mr. Mohammed to come in, and then Ms. Niekerk?
Thank you, Chair, and thank you, Mr. Kutsia, for your amicableness. We agree. I was also going to make that proposal that should we concur that the NEMA appeal provisions apply, we should make the recommendation as in Splume to say that the MSA Section 62 does not apply in the case of appeals. So we can do it in that way. So I think there is agreement, Chair, on that. Thank you.
Thank you very much. Ms. Niekerk?
Chairperson, I was just going to say that our legal advisor also has a view on this matter. I'm not sure if he wants to share it with the committee now. Excuse me.
Mr.
Chair,
yes.
Yeah, thank you. The messages broke up a bit earlier. And I couldn't quite hear everybody. I made a submission via email to Ms. Niekerk, but that was concerning paragraph 4 of this document. I understand that here we're talking about paragraph 7, which concerns the appeal authority.
Okay, good. Can I then ask that we now take a 10-minute break? Perhaps we could stretch it a little bit more, because it seems to me as if Ms. Niekerk will have some information being fed to her, which she may want to incorporate into the document as we then consider it. And therefore, according to my phone, it's now 14:38. Could we then meet again at 14:50? That's 12 minutes from now. And I'll appreciate it if those that do want to make comments or inputs liaise with Ms. Niekerk. I don't know, she must also indicate whether she requires a 5 minutes break as well. But for the next 12 minutes, can we temporarily suspend the proceedings of this meeting, please?
Yes, Chair.
Thank you very much. We see each other then in 12 minutes. Thank you, honourable members. back. Thank you, Ms. Niekerk. Can you hear me? And would you be able to beam your document onto our screens?
Yes, Chairperson, do it right now.
Honorable Maseko, it seems to me as if your microphone is on. Would you like to raise an issue?
No, Chair, I think it's a mistake, sorry.
Thank you.
Are you able to see the document, Chairperson?
Yes, thank you very much.
Okay.
Thank you. Perhaps if you could just go slightly up so that we can see the first paragraph.
This is the first paragraph, Chairperson.
If you could scroll up. Sorry, I would like to see the heading just there.
Over there.
There it is. Okay, thank you very much. Good. So, honourable members, if it's fine with you, I see this is a 10-page document, but and I certainly don't need to read every word in it. But if we could go through this document and if we could even finish that today, it would be fantastic. So just again to read into the record that the Standing Committee on Agriculture, Environmental Affairs and Development Planning, having considered the subject of the National Environmental Management Laws Amendment Bill B14D of 2017, NCOP referred to it in accordance with Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to support the bill. The committee further proposes the following amendments. Ms. Nika, can I just make sure about that 2017? Let me just, is that the version that we were asked to comment on?
That's correct, Chairperson. B14D 2017, yes.
17, I see it there in the left bottom corner. Thank you very much. So general, I'm not going to read every word. I put to you that paragraph 1. Thank you. Then paragraph 2.1, 2.2. I put to you paragraph 3, the definition of financial provision. Ms. Nika, perhaps you can just quickly beam that. I think you can read faster than what I can read.
Would you like me to read it, Chairperson?
No. I think we can do some silent reading. That's what I mean. Silent reading is faster, maybe limiting as it refers, and therefore that we submit that the definition of financial provision is limited to listed and specified activities, and that the definition of page 2.
There we go.
To enable the requirement for financial provision to apply more broadly. Good. Then I put to you 3.2, the term progressive rehabilitation, which we want a definition on. Thank you. Paragraph, can we scroll down to the bottom of the 2.2 and then 3.3? You will recall, honourable members, that we said that it must be safeguarded in the case of insolvency of a mine, for example. Then paragraph 4, latent environmental impacts. Again, it's a rewording, not a serious difference. Then that is paragraph 5, clause 5. again, it's insertion there, and then also a deletion. Good, thank you. Can you move on to page 3, the top of page 3?
Chairperson, this was just what the department took us through now, that we've incorporated.
That first paragraph that we dealt with in detail. So thank you very much. I think that then you may scroll down to the next clause.
Clause 8.
Thank you. Thank you so much. The word to be substituted with the word must. And then also referring to clause 8, there dealing with the financial provision. This is not a duplication of the previous paragraph on financial provision, Ms. Niekerk?
No, Chairperson, this applies to the to section 24P and 24PA of the Nema, which the proposal was that should be amended to enable the requirement for financial provision to apply more broadly.
Won't you just check
but it's
on
linked
the
to the
heading?
definition.
Yeah, just check that heading, clauses 24P and 24P. I think perhaps you may want to change that second 24P to 24PA. Am I correct?
Mark so.
Daar's hy. Dankie. Good, that is number 7. And then paragraph 8.
Yeah.
Clause 20, section 31G. Should also include references to or a municipal manager of a municipality. And then also the word mineral and petroleum resource inspector. I think in some cases the word petroleum has been omitted. Thank you. Which brings us to our paragraph 9. Again, for consistency, that the term be used environmental, mineral and petroleum inspector. Unless I hear any comments, we go on to the next paragraph, paragraph 10. And where we've said that we prefer the term minister responsible for water affairs and not the minister of water affairs, because the name changed sometimes from sanitation, water affairs and sanitation, etc. Good. And then paragraph 11, again, similar. Paragraph 12, again, the minister responsible for mineral resources. 13, to include Provincial Act that substantively deals with environmental management. Can I just ask Mr. Niekerk, will it be clear where that term or that phrase should be included to anybody reading this document?
In my opinion, Chair, it's clear as it stands. I don't know, maybe our provincial department has another opinion, but these were all submissions that was taken from our matrix to which our provincial, to which the national department has responded to say that they support them.
Yes. Okay. Let's hope that it will be clear where that phrase should be included. Thank you. Then paragraph 14. So it's no longer a request, but it should be substituted as an instruction. Not instruct, but instruction. Is that correct?
Correct, Chairperson.
Thank you. Can we go on to paragraph 15? And these are the appeals at local government level. You say the National Department has noted this and has commented as follows: noted need to explore the proper appeal authorities for actions of the municipal manager regarding provisions of the Municipal Systems Act, as well as the merit of other appeal authorities. Again, I do hope that our colleagues from SALGA are still online. So now that the National Department has, I almost want to say, conceded that this needs to be explored.
This was a submission, Chairperson, from our Provincial Department.
Good. And can I just ask, doesn't this also again refer or relate to the discussion that we've had just before our break?
That's correct. Now, what you will see now is everything that has happened prior to our break. This is basically what our Provincial Department has now presented to the committee. I just need to double check, because this was done last night, that what we have here is what the committee agreed to based on what our Provincial Department presented to us.
Good. Can I just ask, Mr. Hardcastle, I recognize you.
Yes, Chair. What I can offer is that we can also, with Ms. Ncop, also just go through this document to double check that that everything that because we've made late changes and that change has been affected, but also go through the document, and if there is maybe some clarity that we can add, we can suggest it, but it's at all just a suggestion that the committee can then it's like the one that you said at Yo, but it's clear. We can just maybe look at it and see if it can be more clear. But we will do that if you want us to do so.
Thank you, Mr. Hardcastle. I would like to accept that offer of yours. Can I just ask, during the break, have you been able to touch base with the representatives from SALGA? I do know there were some sound problems.
Yeah. Chair, I don't know if Mr. Mohammed did that, but I think that we've clarified the differences between us. But the recommendation is that we must just make it clear that the MSA appeal option is not available, and we will add that additional amendment to what we have submitted to you to make that clear. And I think then the differences between us and SALGA have been resolved.
Excellent. And unless I hear from SALGA, I take that also as an acceptance from their side.
Chairperson, this is Anton Kutsia. That is in order, sir. Thank you.
Good. Thank you. Honourable Bartman.
Thank you, Chair. Chair, I just want to find out if the department is going to be assisting Ms. Ncop just to make sure that all of the things that we've agreed to previously are in the draft negotiating mandate. Would it not be possible then for us to then park it so that they can go make sure that the document is correct? Because I'm a little bit unsure about some of the things that are not in the document. Because I do think that we've agreed to more. I see that the document's also only 10 pages, which is a little bit, I don't know, it just makes me a little bit anxious given the amount of documentation we went through with all the things that we agreed to. And given that we haven't seen the draft negotiating mandate yet and the complexity of the bill, it might then give us enough time to then read the draft negotiating mandate, come back and say, yes, we've agreed to this. Let's make sure that the wording is correct in the document. Thank you, Chair.
Thank you, Honourable Bartman. Honourable members, Honourable Bartman, you were breaking up, but again, I don't know if it was a problem on your side or on my side. But what I did get was, and I think that is the way in which we should propose this, if we say we now consider this and we support the various paragraphs, we have been able to secure 2 more time slots this week, and I will at the end of this meeting just ask which of these, my apologies, it seems to me I've been cut off. My apologies, I've just lost connection, that we just, adopt in principle now so that we can show some progress, but that the very last version be presented to us, and as you've said, that there may be some issues which we may have had with the legislation, which we may have skipped now, and that we will consider that at our next meeting, which will then hopefully be a very brief one, and I will check regarding the availability of the members. Good. So in terms of paragraph, sorry, Honourable Bartman.
Thank you, Chair, and apologies if I'm belaboring the point. Chair, I just feel a little bit uncomfortable if we're going to adopt or consider these things in the negotiating mandate now, but then Ms. van die Kerk and the department goes to check that we haven't missed anything, and then we come back and then we adopt or consider again. And I would prefer that they first go and do their checking and the administrative work, that we then get the document beforehand to read it beforehand, and then come back in one of the 2 proposed committee slots that you've identified. And then we don't necessarily then need to go through each paragraph by paragraph, because we've then already read the document and would be able to just identify where we feel that the document do not reflect the committee's views. That's my proposal. Thank you, Chair.
Yeah. No, thank you, Honourable Bartman, and I'm completely with you. I have a saying that work is not done in meetings, work is done between meetings, and yes, quite correctly so, that I think the period in between meetings is a very important one, and that hopefully we will be able to have a to and fro from in between this meeting and then the next one, where we will be served with the next draft of this document. Good. Paragraph 16, I think that one we have now the National Department responded, and it's, yeah, thank you. That this is already provided for in clause 34. So, sorry, Ms. Niekerk, if you could keep it just still for a moment. 34 of the amendment bill, which adds the Municipal Council as an appeal authority for Section 28 directives issued by the municipal manager. And then the next paragraph. This does not clarify, and therefore it is submitted that since the amendments contemplated are intended to bring appeals of decisions made by municipal licensing authorities in terms of Nema under the ambit of Section 43 of Nema, consequential amendments are required to include a reference to the new provision in Section 43.4 and to the municipal appeal authorities in Sections 43.5 and 6. Now, the National Department has indicated that the aforementioned will be considered. Are you happy for that paragraph to remain as it is, or would you like it to be expanded upon? Okay, I take silence as support. Honourable Bartman.
Thank you, Chairperson. Chair, again, I know I'm mentioning it again, but for example, this particular clause, if we want to now check that today's information and the previous information is correct, I don't want to, for example, say support if I haven't gone to go check myself that what our views were correct. And given that we've also obviously received some of this information today, I would feel much better if we had the opportunity to first go through it. Thank you, Chair.
Yes, thank you very much. So if I say support, or if I say good, we move on to the next paragraph, it doesn't mean that we cannot come back should we, having been given ample time to look at this, come to a different view. Good. Paragraph 17, now we're with the Biodiversity Act and the word control, and I think that is what was just presented to us, the systematic destruction over time. So I propose that we move on to paragraph 18. And I think that is where we've said that the MEC should be consulting the Provincial Executive Council. Thank you, Ms. Niekerk. Good. 19. Thank you, Ms. Niekerk. Can I just say, I think that was a little bit of a cut and paste exercise. If we say is hereby submitted and agreed to, perhaps Ms. Niekerk, if you could just put that either in italics or so, and just add a comment that we would just look at that last few words again. Good, thank you. Then paragraph 20, if you're ready for us.
My Word has just not stopped working, Chair. Just a moment.
I think it has happened with others in the past as well when they tried to beam documents up.
There we go.
Thank you. Paragraph 20. I think that is also something which we have just considered.
Correct, Chairperson.
Good. 21. And I think the essence of that paragraph is there at the bottom of the page. That the licensing authority should be empowered to determine the period of extension of the provisional atmospheric emission license. And that is where the license valid for a period of 1 year and may be extended once for a period as determined by the licensing authority. That's our proposal. Then 22, the Waste Act. And again, this is the paragraph that we have just dealt with extensively. Paragraph 23. Good. Again, within a period specified in the notice, but not more than 90 days. Which brings us to paragraph 24.
Chair, this is clause 82, which is the last clause in the amendment bill. And I've just I've just copied and pasted our provincial department's comment on this clause. because I think Member Bartman said earlier, and the committee agreed that it should be inserted here.
Good. So the EMPs, that is where Mr. Hardcastle expressed the department's fear that environmental management programs should not be seen as environmental authorizations.
Correct.
Good. Can you scroll down, Ms. Niekerk?
I think that is it. That's the end of the comment on clause 82.
Good, thank you.
And then at the end of it, I've just included the proposed amendment from Advocate Leroux, which he just emailed to me regarding sections 36(5)(c) of the NEM.
Sorry, I lost you. Ms.
I was
saying, just say that again. You've included, yes? I've included the proposed amendment that was just emailed to me by Advocate Leroux that relates to section 36(5)(c) of NEM Aqua, so that the committee can see it here. Thank you. And since we haven't seen this before, honourable members, I will allow for a little bit longer for us to linger just on this page. I wonder, Ms. Niekerk, if with the assistance of Advocate Leroux, whether you wouldn't be able to just draft this in the same style as we've seen with the other paragraphs. Is it Advocate Leroux's hand that I recognize?
Chair, thank you. I just wanted to comment that this comment by me doesn't really add anything to what SALGA and the Provincial Department has said. I think especially SALGA made the point that this section 36 is probably unconstitutional, and I simply made this note to give a bit more context with some additional support, because I agree with that view by SALGA that the provision is unconstitutional and should be deleted.
Good. So I was wondering, would you be able to just liaise with Ms. Niekerk just to say, because I think that is the gist of what we want to say, is that we believe this to be unconstitutional, and that, you know, we therefore believe that there should be a difference between air pollution and air quality. I think that is, or the monitoring of air quality. I think that is the difference that the department has also tried to make, and that I think we need to bring this in. That's my proposal into our report, but that we perhaps just phrase it in the same style, if I can call it like that, as our other paragraphs in this regard. Would you be able to assist Ms. Niekerk in that regard?
Yes, Chairperson.
Thank you very much. Thank you, Ms. Niekerk. Thank you, Ms. Niekerk. So although at the bottom of my page, it still says page 4 of 10, we are at the bottom of the document. Am I correct?
That appears so, Chairperson. That's it. It's not 10 pages. Good. That's the end.
Yeah. Okay. No, thank you very much then. Thank you, Ms. Niekerk. Honourable members, you have heard particularly also Honourable Bartman saying that we were a little bit unprepared, in the sense that much of what we considered today was only presented to us during the meeting. Now, we did anticipate that we would not be able as a committee finalize this issue or the negotiating mandate today, and that we may need to put our stamp of approval onto this at a slightly later date. Now, again, as I've said earlier in this meeting, we do need to finalize this matter this week. Now, fortunately, we have been able to get 2 additional time slots. One being, if I'm correct, tomorrow afternoon, Ms. Niekerk. Perhaps you can just tell us what are the options available to us to again consider this document before it's being considered in the meeting.
I'm sure, Chairperson. I've actually seen that on the draft parliamentary program that came out earlier, the slots have been secured tentatively. The first available slot is tomorrow, which is the 16th of September, from 3 o'clock until 5 o'clock. And then the other slot that is available is on the 18th of September, which is Friday, from 12 o'clock until 2 o'clock. All right.
Thank you. So, honourable members, if you say that that slot is available, it does mean that members don't have other parliamentary obligations, but I do know, honourable members, you may have also, since receiving that document, made other commitments, private commitments or commitments in the party political leg of your task. Would we be able to meet tomorrow? You say tomorrow at 1 o'clock, Ms. Niekerk?
No, Chairperson, at 3 o'clock.
3 o'clock, my apologies. So, honourable members, can I ask that Ms. Niekerk is now going to liaise with, for example, Advocate Leroux, and will hopefully be able to forward us an amended document this evening or tonight, and then that we meet tomorrow at 3 o'clock, and if we don't finish by 3 o'clock tomorrow, that you also keep Friday open. But I think I speak on behalf of us all that we do hope that we would be able to finalize this matter tomorrow afternoon. And can I also ask, please, honourable members, that we all go back to our notes, and if there are other aspects that we pick up that may have been omitted, or where we believe that further debate is needed, that we also not wait until the meeting to inform Ms. Niekerk of that, but that we will try to raise those issues as early as possible with her, to also in this way add to the efficiency of this process, so that hopefully what we consider tomorrow afternoon will already be, if not the final document, very close to a final document. Would that be in order with you?
Chairperson Deirdre Bartman.
Please go ahead.
Chair, I'm unable to meet tomorrow. I have a meeting from 4 to 5 that I'm unfortunately unable to reschedule, as that meeting involves a minister as well, and their schedules are quite tight and the meeting needs to occur quite soon. But I do support the Friday meeting. And just a comment, my concern isn't the capturing of today's amendments. My concern is the correct capturing of the previous amendments, because in comparison, today's amendments weren't as voluminous as the previous ones. And I do wish to go through the comments and amendments we've agreed to previously, because when I look at the document overall, compared to the amount of information we had previously, it does not seem comparable in terms of that. Thank you.
Thank you. Honourable Bartman, can I just ask, you've indicated that your meeting tomorrow is at 4 o'clock, and I'm just concerned that if we postpone until Friday and then discover that there are still aspects that are in need of attention,
Chair.
my apologies, I was again quickly cut off, that we that we, one of the advantages of meeting on this platform is that one can quickly, enter the meeting and exit the meeting. So would we be able to meet tomorrow, let's say from 3 o'clock until 3:45?
Chair, Member Masek, I won't be able to do that tomorrow. I already have an engagement in Caledon.
Good. What I heard, Honorable Maseko, is that you say you wouldn't be able to meet tomorrow.
No, I won't be able to
Okay.
be available.
Okay. Good. So, honorable members, that means that we will have to look at Friday, but it also means that we will have to hopefully iron out all issues with the document. I almost want to say offline, outside of the meeting, and as I've said, the bulk of work gets done outside of meetings. So, can I ask that we then via email or via WhatsApp groups, just keep each other informed?
Via email, yes, Chair, not via WhatsApp.
Yeah, okay. Via email, my apologies. It seems to me as if my computer or internet connection is also thinking this day has been too long. So let's keep each other informed. Let's keep the communication open also with Ms. Ncop. And then, Ms. Ncop, you say on Friday we would be able to meet?
From 12 o'clock until 2 o'clock, Chairperson.
Yeah. In the morning, Ms. Ncop, in the morning we do have SCOPA. And I'm going to check, Chair, if it will be possible for me after that, because I already had an appointment with the doctor on a Friday. I will see if it will be possible to be postponed, but if not, that means I'm not going to be able for the coming 2 days to be part of the meeting. We can check if we can have an alternate that can come in.
Okay, thank you, Honorable Maseko. I appreciate that, and we do hope that those meetings will be brief. And Ms. Ncop, if there are any additional input received, would you be able to also put that in a parallel document with where the changes only are marked, so that we don't need to spend our time on paragraphs that we've already seen?
I'll do so, Chairperson.
Good. Thank you very much, honourable members. Ms. Ncop, you also would like us to just look at the 8th of September's set of minutes. Have you been able to circulate those? Because
yes, I have, Chairperson.
Good. Will you be able to beam that onto the screen as well?
There we go. No, not yet.
Sorry, Mr. Chair, if I may ask, there are still the departmental officials. Is it okay if we excuse ourselves?
My apologies. I should have released you. You
Yes.
are most welcome. Thank you, Mr. Mohammed, and thank you very much, Mr. Mohammed. I don't know if you were part of the meeting last week when Mr. Hardcastle said, or actually complained about the amount of work that you give him to do over weekends. But we really appreciate the work that both him and Ms. Rousseau have been doing in preparing for today's meeting. And the fact that it was only forwarded to us this morning probably speaks to the pressures that your officials are under. So thank you very much. We appreciate that. Thank you, sir. Thank you, and thank you for the compliments. I will surely make sure that my HOD gets to learn about that. And then if Ms. Ncop can just then be in contact with us, the team, the normal team that she's dealing with, and then we can assist in polishing the document up. Good. Thank you.
I'll do so.
Okay. Thank you, Mr. Mohammed, and thank you. You are released. Thank you. Okay. Good afternoon all. Bye. And Ms. Ncop is still looking for the set of minutes?
I have the set of minutes, Chair. I don't know, Word is just not responding again. But these minutes were circulated to members.
Ms. Ncop, I'm very glad to hear that our aeroplanes are again flying.
Pardon me, I'll turn off my speaker.
We're just trying to get that onto your screens, honourable members.
Chair, it's going to be difficult for her. She is in the skies in a helicopter.
Okay,
Just give me a minute, Chief. The word is responding now. It's just kicked me out. Almost there.
Ms. Ncop, shall I try to share from my side?
Chairperson, you can see it, but you can see there's something
there it is.
not right here. Yeah, but look at that.
I see you've suddenly started typing lots of open space in between the words.
Yeah, but I just hope members can just see the other detail.
Yes. Thank you very much. Okay, so I think, honourable members, the attendance register has been checked, and I trust that you all agree with that. Then the officials, thank you, Ms. Ncop. Good. Sorry, that's correct. That is when we didn't discuss clauses 1 to 32, as it has been discussed in a previous meeting. Thank you. Ms. Ncop, please scroll down. And that's when we asked the department, Western Cape Department, after having considered the National Department's response, to come back with appropriate wording on the following clauses, which they have now done.
Correct.
And you will just double check that those were the clauses that we highlighted at our last meeting.
Yes, Chairperson.
Thank you. Good, and we requested that they scrutinize the proposed amendment and inform the committee if they are satisfied with it. And it did happen in a number of paragraphs where they've said that they now step off their concerns.
Sorry, Chair, is this being as the same, is there any changes on this one, or is the same with the one sent to us?
It's the same one that was forwarded to honourable members. Just if you could just scroll down to the very last paragraph, Ms. Ncop.
Very last one.
Or that resolved, that's it, that's it.
Okay.
Thank you. Are you going to propose, Honourable Maseko, that we...
I'm going to propose that we adopt the as chairperson.
Thank you very much.
I'll ask a question, please.
Honourable Bartman.
Don't.
Chair, for example, this relates to the similar comment I made previously. For example, I remember making a comment regarding section 37, which is a proposed amendment which the department made regarding the atmospheric licenses and ESCOM and stuff. And those are neither, for example, in this document, neither in the other document that has been prepared. And given that this minutes relates to the document that we're going to be discussing on Friday, this is just one example of what I was trying to explain, that I don't think that everything has been included. I don't think what is there is not correct. I do think that is correct, but I do think that there might be some information missing that we did highlight, Chairperson.
Okay, now I think it helps if you're being specific. You said it's section, is it 37?
Chair, I made an example of the proposed section 37 amendment by the department.
Okay, so just help me. Would you like Ms. Ncop just to go and listen to the recording again?
Yes, Chair. So based on my previous comments, I would like, after the department and Ms. Ncop has gone through it, after she has consulted legal, Then once we've received the document in our email, given the complex nature of this bill, if it was 2 or 3 clauses, I do think it would have been easier for us to have just gone through it and said yes, no, yes, no. But given the amount of clauses and the amount of amendments we've gone through and everything, I do think that it's important for us to just check that everything we've asked for is included in the documentation.
Okay, good. Now, thank you. So what you're proposing is we don't adopt today, but that we just give Ms. Niekerk an opportunity. I see in paragraph 3213, there is reference to section 37, and perhaps Ms. Niekerk could just, check for us whether what is being captured is the full extent of what was needed. Obviously, minutes being derived from the word minute cannot, capture each and everything that was said in a meeting, but whether what was adopted then by us is in line with what has been minuted there. Okay, so honourable members, if you do find that other paragraphs may also be requiring similar attention, please highlight that with Ms. Niekerk in between now and Friday morning. And Ms. Niekerk, having considered but not adopted the set of minutes, we've just referred it back for some further scrutiny. Can we then just agree that we will meet or see each other again on Friday at 12 o'clock to hopefully then finalize the negotiating mandate to the NCOP? Ms. Niekerk, anything else that you still require of us?
That's fine, Chairperson.
Good. Then, honourable members, I really want to say thank you very much. This has been a very difficult path. This, I think, compared to other amendment bills, has been quite a hefty piece of work. And I've found it extremely enlightening. I must say I've never even, engaged with all these environmental laws in the way that we have. And I want to thank you all, particularly those of you that have listed a number of issues that you believe that should be addressed or wanted clarified, etc. And with that, honourable members, I'm going to close this meeting, and I'm looking forward to your inputs in between the meetings, and hope to see you all then on Friday morning. And if you're not available, please, if you could organize somebody to stand in for you, I'll really appreciate that. And with that, our meeting is adjourned. Thank you very much.